Democratic management system assumes a strategy which uses the state property in the interest of society. However, when the privatization of that property is legally permissible, then presumably the interests of the owner and the public often don't coincide, and corruption risk factors are just growing in this core. Very often we can see the corruption mechanisms in connection with the price evaluation methods, because it depends on the fact which method you choose. That's one of the main problems in the issue of privatization. While in reality the privatization of state property is an integral part of economic relations of the country and clearly contributes to the economy, nevertheless some special purpose institutions must be out of reach for privatization. Naturally, we have no guarantee that, for example, such buildings of cultural value, buildings forming a part of cultural heritage, will not appear, sorry for my expression, but in the clothes of known or unknown rich people in the result of the same shady deal. There is foreseen by law on state property privatization that for some state structures and buildings of historical value, some procedures are somewhat different. The government, when it gives a decision that they must be realized, must indicate that after realization they must be used with their purposes. However, I believe that there are corruption risks here too, because at least for such important historical buildings, the realization must be by law and not just by the government decision. If there is made a wrong decision, is it controlled in any way, and in case of wrong decision, how is the possibility of cancellation of it? There are procedures in general, but as we know, very often the procedures just remain on the paper, as defined by above-mentioned law. When the government writes the program that the property should be privatized, the latter should carry out that through the National Assembly. It means that there are some mechanisms, but in practice we cannot say that there are some great solutions. The situation is further confused when information provision is limited for the citizen. For example, the citizen can request the provision of information and try to obtain information on the fate of some object of community importance, for example, on the process of privatization. But the problem is that everything is covered, you know. They don't answer, they avoid of it. For example, if they don't answer, well, the citizen applies to the administrative court for getting information, paying much money for that. Let's talk real. A citizen will ask. If he doesn't get any answer, he will remain silent, because there are attorney costs, etc., etc., excessive red tape, perhaps supposed pressure of interested shady owners by predictable or unpredictable ways. Armenian Association of Lawyers sees the reduction of corruption risks present in the field of privatization of state property through the introduction of the Institute of Real Owners, and there have been already taken certain steps in this direction. Why this institute has a fundamental importance for us? Because here is very often when one person can create a number of companies, that company can be the owner of other companies and the final real owner, but the real beneficiary is not clear. The investment of the Institute of Real Owners will be effective if these owners are protected. The whole problem is that regardless of whether a person is rich or poor, is a large owner, or if the person has no property at all, he is not protected. That's the problem. If these guarantees don't work in legal practice, the jury paper versions have no value. The state is recognized strong only in such case when they are protecting the interest of the citizens, and this is the only motivation which is to be guided. Հայր Փիաղաջանյան, Դավիթ Եսայան, Սյունիք Online.